Hello, everyone, and welcome to today's discussion on competition law reform in Canada. I am Catherine Murray, your moderator for today. MLI has assembled a great panel to discuss the recent changes to the Competition Act passed as part of last spring's budget and what it might foreshadow. This fall, the federal government will launch a consultation on potential reforms to the Act. And I think we can all agree that the goal should be maintaining dynamic and fair competition within Canada so that we continue to achieve economic progress. The question, of course, does remain, are we achieving that in the proposed changes? Do we need a fundamental shift or do we need tweaks to the current status? To weigh in, let me introduce our panel today. We have Daniel Sokol, is the Carolyn Craig Franklin Chair in Law and Business and Professor, USC Gould School of Law Affiliate Professor, USC Marshall School of Business, a Senior Advisor at White and Case, and one of the top 10 most cited antitrust professors in the past 5 years. Welcome, Danny. Anthony Niblett, unfortunately, is ill today. We do have Aaron Woodruff joining us, who is a lawyer and the director of the Domestic Policy Program at the Macdonald-Laurier Institute. Welcome as well, of course. And Erica Douglas is an associate professor at Temple University, Beasley School of Law, and previously a lawyer practicing antitrust and technology law within Covington and Burling in Silicon Valley. And her scholarship focuses on the intersection of antitrust and data privacy. Welcome, Erica. And we certainly look forward to this conversation, one that is needed and so relevant for all of us who care about, again, having a very dynamic place within Canada. Aaron, let me start with you in terms of looking back at the proposed changes from the budget last spring. Can you recap them for us and perhaps even tell us from your perspective what stands out? What do we need to know?
Yeah, well, thank you very much, Catherine, and I'll do my best to pinch it for Tony today. We're sorry to miss him, but in terms of recapping what happened in the spring, I think a couple of notable things. First of all, was the speed at which these changes came about. These are some pretty significant changes to the Competition Act. They were presented as part of the Budget Implementation Act, otherwise known as an omnibus bill. I think that raised quite a few eyebrows because with these sorts of changes, it's usually something you want to take your time with. You want to consult with stakeholders. You want to avoid, of course, unintended consequences. And we didn't see that in the spring. So I think there's still a lot of ambiguity around what some of those changes mean. A few things that were particularly concerning, certainly from MLI's perspective, was the administrative monetary penalties, the AMPs. There was a feeling, of course, that penalties for anti-competitive behavior had been too low. They'd been, I think, a maximum of $10 million. People can agree if you're a sort of large digital giant, $10 million is chump change. So the thinking was we need to raise those penalties. I think that's a fair argument, but they raised it to a maximum of 3% of worldwide gross revenues. So now you could be getting into, hundreds of millions, billions of dollars. So I think we've sort of swung from one extreme to the other. And I don't know that enough thought has been put into what some of the unintended consequences would be about some of these large tech companies. Would Canada become a place where the cost of doing business potentially becomes prohibitive? So that's certainly one big concern. And then, of course, there was a change to the definition of what constitutes an anti-competitive act to now include harm to competitors as opposed to competition generally. And of course, these are different things. This is a significant departure from what we might call the consumer welfare standard. Why do we like competition? Because it's good for consumers. It's good for Canadians. And now with this change, the Competition Bureau has to be seized with whether or not there is harm to competitors, which I think raises some interesting questions because it implies there are fair ways to compete, there are unfair ways to compete. I think that's true. But how you're going to separate that, how a competitor that just does a great job in the marketplace but does harm to one of their competitors could potentially run afoul of the act. So I think those are the sort of things that certainly caught my eye from the spring changes in the budget.
Okay. Danny, would you like to weigh in terms of what stood out to you? And of course, your focus is so much in the United States and globally. Is there anything when you take a look at the changes that have been passed that, might be a bit of a red flag to you? I think we might have Danny.
Sorry.
There we go.
So thanks for having me on the program. few disclosures. I'm speaking in my personal capacity. Second is just in terms of my own consulting work. I do both work against big tech companies, for big tech companies, for industry associations, for and against companies that are big and tech, but technically not big tech. And with all of that, I'll just sort of begin with what's interesting. So first of all, I think that the Competition Bureau is very effective, very strong leadership, very high quality staff. Biggest problem, I think, is funding. They have a significant mandate and there's a lot to do. And simply to be able to ramp up to do more than what they're already doing, they need more money. So that's on one level. Second level is, are we even thinking about issues the right way? And how do we think then about the changes? So Aaron, I think, pointed to some of the peculiarities of what we saw that may have been unfortunate. I think that, more fines is fine up until the point where you're chilling behavior. And I am also concerned about that. So what are some of the initial thoughts that I have about where we've been recently and where we're going? So Tony and I had written a paper, which is that, going after tech is fine. It's even, and especially when we see traditional anti-competitive conduct, turns out the existing laws really allow for that, both on the merger side and on the conduct side. And in a world of digitization, where we think of data being important, we have the Toronto Real Estate Board case, which shows that the Bureau can win these kinds of cases. So when people say we need new powers, the big question is to do what? What is it that existing law doesn't allow you to do? If the problem is we don't have the resources to bring the kind of cases we want to bring, that's fine. Let's increase the resources. Are there some aspects to Canadian law that might need to be reformed? Yes, some of them are just not in the very sexy areas that we normally think about, that you might see endemic in oligopolistic markets, and we could talk about that more. But to the point of unintended consequences, I think this is worth noting. So I'll give you an example from elsewhere in the world. So in Europe, they really care about privacy. So they passed GDPR. So we'd say higher privacy. Who could be against that? Well, it turns out there are a lot of unintended consequences because of the nature of how GDPR works. So what do we know empirically? Number one, there's less AI investment. And that's a paper written actually by two of my co-authors, Ginger Jin and Liad Wagman. We have higher concentration and more consolidation. So that means that competition actually seems to be at odds with greater privacy. And oh, by the way, another interesting working paper by Joel Waldfogel at University of Minnesota, so not too far from the Canadian border. Fewer apps. So again, passing some kind of legislation in principle always sounds fine. There are unintended consequences, and sometimes it's not immediately apparent, but sometimes it really is very quickly apparent. And when you care particularly about investments and increased R&D and intangibles, changing the rules that might mitigate the otherwise wonderful story about tech in Canada, where at present in all of North America, Toronto now has more tech workers than any other geographic areas other than the San Francisco Bay Area and New York City. That's a real problem. Or put differently, we can tell the story of two former British colonies, roughly the same size, that in the year 1900 looked the same, Canada and Australia, where the production was mineral extraction, animal protein, and grain. And 120 years later, that's exactly what Australia still produces. And yet, Canada has flourished largely because of technology and innovation. I'm concerned that that might be at risk with rules that don't quite make sense. Thanks.
All right, that's really quite fascinating in terms of just thinking about, in Europe, less apps, less AI development, given the focus on privacy. Erica, let me ask you to weigh in as it relates to your reaction to the proposed changes, and also, of course, your focus on, in the past, I suppose, big tech and privacy trying to work together. I mean, where does it stand now? It's quite interesting to see less interest in developing technology if you've got this overriding competitive laws and acts that prohibit you from growing how you want to grow if you're in the tech industry, as an example.
Yes, thank you, Catherine. Thanks so much for having us, Aaron. I think competition policy has never stood alone, and that's part of sort of what we're hearing so far. It's always been part of a broader toolkit. It used to interact and still does with telecommunication law and agriculture law. But the digital economy is really pressing those interconnections further. The relationship between competition law is growing to intersect more with labor law, for example, with the new focus on monopsony, power, and wage fixing. There's interaction with these digital regulatory regimes. And then there's interaction with data privacy law, which is where I do much of my work. And all of that's inevitable. I don't think there's any choice there, because the digital economy really presents this avalanche of multidimensional policy challenges, right? They span legal doctrine and they span the bounds of agency jurisdiction. And so we see these cases and legislation that really cross over between what we might have traditionally considered to be doctrinal areas of law. A good example of that is the attempts to regulate digital platforms, where we see in the US almost antitrust-like regulation against things like self-preferencing by platforms. And we also see cases that claim, for example, from US antitrust enforcers, that monopoly power is being used by big tech to reduce data privacy. And we also see in Canada that the BIA amendments to the Competition Act introduced the term privacy to the Competition Act. And all of that reflects a big debate over the role of competition law and policy in a microcosm. If competition policy, if we think it is too narrow to face the challenges of the digital economy, then we might, and I don't accept that premise, but if we might for a moment, then there's sort of two broad paths we could take to fix that. And one, which the US in some sense is going down, is that neo-Brandeisian school of thought. These policy thinkers, which now lead US antitrust enforcers, have this sort of expansive vision of antitrust law, that it could be used to bring privacy protection and labor protection and small business protection into the fold of competition law. And that's where you see the departure from the traditional consumer welfare perspective that Aaron was mentioning. For privacy, I don't think that is the right approach. It sort of unnecessarily confuses antitrust doctrine and privacy doctrine. And so I think the second path here, and the one that for a large part Canada has been going down, is to use privacy law to protect privacy, right? Canada also has proposals for stronger privacy law, but at the same time build the interactions between these areas of doctrine and the digital regulatory landscape. And I think that's where the BIA faced some challenges that weren't really talked about. We've done the headline news, but here is, I think, a latent problem with the BIA amendments. So the way that they went about integrating the term privacy into the Competition Act was to add it as a factor. They said quality or consumer privacy are now relevant to mergers, abuse, and civil agreements. I think that is likely to cause confusion, because if you step back for a moment and just understand how privacy has been understood by competition law, there's a really close to consensus view that in some markets, we will see privacy as a parameter of non-price competition. Think about how you choose your phone, how you choose your browser. It's possible that privacy is one of the factors that you take into account when making those consumer choices. To your question, Catherine, we've assumed that when privacy improves, competition improves, and vice versa. And that's the privacy as quality paradigm that's really taken hold. But this widely, increasingly accepted view is not really reflected in the BIA amendments. They kind of regress from that view, or at least confuse it, because they've bifurcated the idea of quality or the idea of privacy into two separate things. And that just leaves a massive question. If privacy isn't part of quality, then what is it to competition law? In Canada, how do courts and agencies understand the appropriate balance of competition law where it interacts with privacy? And I think that really takes us back to an earlier dilemma where we're potentially trying to use competition law to protect privacy. It revives sort of old arguments that we saw in the US in mergers like Google's acquisition of DoubleClick in 2007, where privacy advocates were trying to get competition authorities to protect privacy. And I don't think that's an effective way of achieving privacy protection in the digital economy. So all to say, I think there are some hidden issues that are going to come out, particularly because Canada is a jurisdiction with both strong competition law and strong privacy law. Thanks.
Interesting. So it seems though there could be some very competing forces there in terms of privacy and competition law. Danny, do you want to weigh in on some of Erica's comments and also perhaps give your perspective in terms of, you know, what this might mean for mergers and acquisitions within Canada? Where do you think there might be some hidden, I don't want to say agendas, but what do you think they're thinking?
Sure. So I agree with Erica that this is really tough. And I guess the traditional paradigm, and Erica has done a bit of writing to change this paradigm. The traditional one is that competition and privacy, at least as we think about it from the legal perspective, is that these were always complementary. And Erica has shown in her work that that's not always the case. And empirically, we know that's right. Shout out to a different Canadian, Avi Goldfarb, also was doing this on the marketing side, as was a different Canadian, but one who lives in the United States, Garrett Johnson, who is in marketing at BU, who also has worked along these lines. How this plays out, I think, is interesting. So sometimes it could be a dimension of quality competition, but not necessarily in ways that people understand. It's a little harder, right? So we know that, let's say, for a traditional quality factor, so let's say hotels, not all hotels are the same. We might compete with larger screens for televisions, better food and beverage service, or frankly, a swimming pool in the hotel. This is fairly clear. People know what they're getting in terms of the quality trade-off. The problem with privacy is there's what we say we want in terms of privacy, and then what we actually want. And revealed preferences are actually quite different. A lot of times we say we want privacy, but yet we're more than happy to trade it off in ways that we wouldn't trade off the swimming pool in the hotel in downtown Toronto. So that complicates it. Now, from a standpoint of a competition authority thinking about mergers, thinking about various mergers going forward, is this something that the Competition Bureau and frankly authorities across the world have looked at? The answer is yes. We've looked at price versus non-price factors in mergers for decades. This is in fact not new. Somehow the idea that this is something we haven't seen before isn't quite right. So we've seen it both in traditional industries and more dynamic, innovative industries. And then the question is, how do we create functional rules that basically don't chill pro-competitive behavior, but also that doesn't give a free pass to mergers that might be anti-competitive? And this is where it's hard. And this is where it's not clear to me that legislation is the right way, but frankly, it's agency practice, it's guidelines, it's actually trying to understand better how industry works, in particular, the use of all kinds of data analytics that might play in this way. And to the credit of the Bureau, they created a data team that both focuses on better operationalizing and optimizing the flow of data that comes into the agency, in terms of basically document review, but also in terms of thinking about how to address these kinds of issues, to take a much more serious role in data analytics. And I think from that standpoint, it's a lot of trial and error. Merger control by definition is about uncertainty, about trying to predict the future. And frankly, you do that better with more, from a merger perspective, more opportunities to review cases, asking the right kinds of questions. But to ask the right kinds of questions, you have to be thinking about the framing. You don't need legislation to do that. This is how authorities around the world think about all kinds of issues. And it's just an iterative process, and you get better. And then you maybe reframe your thinking as you have a little more clarity as to how particular issues might emerge.
So it sounds as though then there needs to be some type of law and regulation, obviously, as it relates to mergers and acquisitions. But at the same time, to your point, Danny, it is such an iterative process because, the world is fast moving, even more so every day, with new analytics and new data collection. And to your point as well, some people actually do like the data working for themselves because they get fed exactly what they want. So, it's, you've also got human nature at play as well. And for right now, it seems everybody kind of wants a little bit of, give me what I want right now. It seems to be working, but then to your point, they also want privacy. So a lot of different moving pieces and parts. Aaron, let me ask you on that front, when you look at the reforms from the spring, where do you think we stand as it relates to, new reforms and allowing for an iterative process here in Canada?
Well, I think, as I mentioned earlier, part of the big problems with the spring consult was it was so rushed that there's still a lot of ambiguity about what a lot of these measures mean. So it's really hard to put your finger on it. I think there is, as you mentioned, there is a consultation that's going to take place this fall. I'm hoping that will be a little bit more robust. I think that will involve a little bit more, consideration of some of the trade-offs involved here. One of the things that's been debated, for example, is the idea of self-preferencing. So, for example, if you're a digital platform, you're Amazon, you want to sell certain products, so you type in, I'm searching for a hat, and Amazon can put its products at the top of the list. Now, on the one hand, this is normal in retail, right? If you go to Walmart, they can put their sort of house brand on the shelf and they can put the competing brand somewhere else. So in that sense, there's no difference. There is a difference in the information that the platform can collect. They know more about you than Walmart might know, right? Walmart knows how much it's selling, but it doesn't know as much about the buyer. And then this gets into the issue that Erica had mentioned about privacy and data privacy. And then to what Danny is saying about what revealed preferences are. We might think, to constrain the power of Amazon, we're going to limit their ability to collect information about the people buying on their platform. But if, as Danny says, a lot of people say, I'm willing to give up my privacy if it means that Amazon is going to show me things that I like and that is actually going to save me money. And to me, that's the real question around self-preferencing. Is it's difficult to define what's legitimate versus not legitimate. And at the end of the day, if it is something that's good for consumers, again, coming back to the consumer welfare test, is that something we want to restrict in the interest of protecting some of the competitors in that space?
Fair point. Erica, do you want to weigh in a little bit in terms of where you see the crossroads right now in Canada and what you are going to be concerned about? What do we need to know as we are in this fall time of consultation? What should we be advocating for?
What should we be thinking of? I think that there's a big opportunity for Canada to lead in developing theories and best practices in this space of competition and privacy, as I mentioned. And I think a lot of that is going to be around agency interactions, which I don't know that the consultation actually needs to address. I think the Bureau has plenty of agency interactions that it's competent to build. But if you look, for example, at its interactions with the Office of the Privacy Commissioner, it's an MOU from 2013, and all it mentions is CAN-SPAM. So in some sense, there's some foundation there for them to build on sort of robust agency interactions. But I think that this is a place where there's room for a lot of growth in Canada. The leading jurisdiction, far and away, and a good model for what Canada could do has been the UK on this. So the Competition Markets Authority is already carrying out joint investigations with the ICO, which is the privacy entity and enforcer. They investigated Google cookies and their third-party cookies policy. They have an MOU on how the agencies are going to interact. And they have also something called the Digital Regulatory Cooperation Forum, which is sort of like an exoskeleton that enables cooperation with their telecommunications, privacy, and competition enforcers. And in some sense, that might strike fear in an industry that these agencies are now going to be interoperating with each other, but I think it's almost inevitable that they're going to begin to cooperate more. And then in some sense, it could be good news in that they will coordinate their investigations. You will get one request for information instead of 3. And there will be some coordination in terms of if we understand there occasionally to be tensions between competition and privacy, then if you won't have one regulator asking you to do something and another regulator asking you to do something else. So I think effective digital regulation is going to focus around that. So that's an area that I would be thrilled to see Canada pay more attention to as we go forward. And I don't think the consultation has to be part of that. Danny, thoughts on the consultation?
So I think when we think about the consultation and we think like, oh, the rest of the world is moving in this direction of more legislation, let's actually take a step back and what is the rest of the world doing? Because I think it's more complicated. So we're told, oh, there's a big rush, everyone is legislating. That's not quite right. First of all, there are different models of ex-ante regulation. So think about the DMA on the one hand versus what had been proposed in the UK, unclear whether or not it'll push forward, which is a much more collaborative process with industry, focused on some kind of joint regulation, which looks different than Germany. Some countries actually dispute the need for broad ex-ante competition regulation. Japan, for example, Korea, Brazil. Some enforcers seem to favor competition law over regulation. And that, again, at least at the moment, seems to be Brazil and Mexico for countries in North America. In the United States, we haven't passed any legislation yet. So at least at the moment, we put the United States in that category. And I mention all of this to give context because we are fed, like, oh, there needs to be change. So that's fine. Then the question is, what is it that existing law doesn't do? And sort of what's the basis for it? Is it something empirical, in which case, show us the results? Is it, we're seeing this in other countries? Well, we're not quite seeing that. In fact, we've seen expressed concerns, for example, about the DMA's impact on innovation. So we've seen this with some European officials and the German government about whether the DMA can be meaningfully implemented. There's some lack of clarity. So I say all of this about the consultations to think long and hard. What is it that you want? What is the objective function that you want to achieve? And what is the way that does it best? Because we have lots of storytelling. And at this point, it does seem to be focused on storytelling largely through tweets.
Can you give us an example, Danny, of that? Like, what were you referring to?
Everyone who's angry seems to put it out on tweets. I used to just think it was Elon Musk, but apparently there are lots of Canadians that do so too. And specific to competition law, we're given just angry screeds, and it turns out politicians seem to be responding to tweets. To a certain extent, the Bureau, just sort of seeing a change in political mood, also responds to tweets. To a certain extent, it's not our fault. It's just speaking about sort of the tech echo chamber. We get an echo chamber in Twitter land. Most tweets are negative for the same reason that you might expect. You get more eyeballs with negative news. And all kinds of claims. And my simple point is substantiate the claims and then tell us what is it that needs to change. So I think consultations are fine. You should always on a regular basis be thinking about how do we tweak the system? if you have exactly the same priorities year after year, this is not like in hockey where the priority is always the same: win the Stanley Cup. The question is, how do you win the Stanley Cup? And strategy changes year to year, and frankly, it should be the same way with the Bureau and the broader competition policy system. My concerns actually are a lot like Erica's, that competition is just one part of a broader tool set, and we have to make sure we're using the right kinds of tools, because when you have a hammer, you begin to believe that everything looks like a nail, and it's just not that way.
I want everyone watching to know that they can submit questions on the platform that you are using, whether it's Facebook or LinkedIn or YouTube. We do have some questions already that were sent in, so we'll get to those in just one moment here. But before we do that, I do want to get everyone's reaction to modernizing the penalty regime. We talked a little bit about it from Aaron's perspective, but I think it is interesting, a proposal for up to 3% of global revenues. What would that do to companies wanting to compete in Canada? And what are the constitutional legal questions that it would even involve? It seems like there would be an incredible amount of details that would need to be worked out. But Danny, can you just respond to that question, your thoughts there?
Normally, turnover, we might think of not as global turnover, but turnover within the jurisdiction. And, were the penalties in Canada low before? Yes. The question is, what happens when they're too high? So I think we could think from a business perspective. There are countries that you must do business in, and then there are countries where you have a choice of whether or not you should do business and how significant the business should be. And what Canada is facing, we might say, looks very similar to what penalties might look like in Korea, Taiwan, Australia, countries where you have a choice whether or not you have to be there. And if the legal regime is such that penalties are too high, what is that magic amount? Unclear. But 3% probably isn't that too high, because it's 3% of global turnover. The choice is, let's minimize our Canadian exposure. And we, to a certain extent, can see this. I want to go with one of my favorite companies in the United States that limited Canadian exposure. Two of them, actually. Number one, Trader Joe's didn't enter Canada. It's too bad, because everyone here loves Trader Joe's. And it wasn't worth it. And frankly, on labor issues, Target was in Canada. The labor regime is what scared them away. Target is now out of Canada. I love Target. Canadians are really missing out on Target. So between Target and Trader Joe's, those are the scary stories of what happens when the Canadian regulatory regime is stricter than what certain businesses might want to have, and they have a choice of, say, limiting their exposure to the Canadian market.
Those are great examples. Certainly we watched the Target story unfold. I didn't know that that's why Trader Joe's wasn't here. I was hoping it was coming. Maybe not. Erica, do you want to just weigh in on your thoughts in terms of the penalties, and then we'll get to some questions.
So Danny hit the nail on the head, because Trader Joe's and Target are the real reasons I live in the United States. No, but joking aside, I think if we look at the EU experience, which is further ahead than the US and Canada when it comes to addressing big tech, they have fined big tech repeatedly to relatively minimal effect, and have now turned to regulatory regimes. So I think it's almost an aside, the question of the fines, because there's going to be behavioral remedies that are going to play a role here, either remedies or regulation. And then I will raise the same concerns before. There's sort of this chorus of calls for compelled access to data from these digital platforms, sometimes in the form of interoperability obligations. There's a flurry of US bills around that. And I think that when we're considering those sorts of data access remedies, we really have to think about the nature of the data that's at stake, which is our personal data. It's our tweets, it's our posts, it's our location data, and that's different from what it used to be when we were thinking about antitrust remedies. And so what I've seen here is a great risk of sort of privacy not being taken into account in designing those sorts of behavioral approaches, where the emphasis is really on data flow, not data protection. And I think also there's been some threats to sort of the agility of technology platforms to respond to privacy and cybersecurity concerns. For example, one of the bills would propose to have, when an interoperability change was going to be made by a platform, they would have to appeal to the FTC to get approval to make an interoperability change. And that's going to ossify platforms in a way that's disadvantageous. So fines are, I don't mean to exclude them from the conversation, they're definitely there, but I don't think that they're really a solution. I think the more interesting conversations are around behavioral remedies and whether we can design for both privacy and competition. Thanks, Catherine.
A lot of questions in terms of how do you design that. I do want to get to some questions. We've got some really interesting ones. And again, please feel free to send in your questions on the platform that you are using. Question from David. He asks, Canadians generally support competition, but not in healthcare. Are there any remaining legal maneuvers that might challenge the government's Medicare monopoly? Aaron, do you want to take that one?
Yeah, sure. That's a really interesting question because, as Canada famously has a universal public healthcare system, I actually would challenge the notion that Canadians generally favor competition. We tend to think we do, and I think when there is competition, Canadians like the results. But you look at a lot of our sectors. I mean, the focus right now, of course, of the spring changes in the fall, the discussion is all big tech. They're very visible. It's sort of held as a prior that the digital economy is different. The pandemic has, sort of made them indispensable to our lives. So that's where all the focus is. But you look at our telecom sector, you look at our airline sector. We do not have robust competition in a lot of areas. So if you want to talk about having better competition, it seems to me that there are a lot of other sectors that are not getting their due. When it comes to healthcare, most of the challenges to this that have gone to the higher courts, the courts of appeal, the courts are being very deferential on this. It's really going to come down to a policy choice. Of course, it is an area of provincial jurisdiction. There is the Canada Health Act, which puts the provinces in a bit of a straitjacket, but there is the potential there. And if you'd asked me this before the pandemic, the likelihood of competition in healthcare, I would say slim to none. I would say that since the pandemic and since most Canadians have had a closer interaction with the healthcare system, and while they're grateful for it, recognize something needs to change. They recognize it is fraying. It is going to buckle at some point, just as demographics change. And so I'm hoping that there will be more openness to this. And I think you're going to see that reflected in, increasingly we're seeing more politicians of varying stripes sort of speaking up about this and the need for more private involvement and more competition in healthcare.
Danny or Erica, would you like to weigh in terms of, are there any remaining legal maneuvers that could challenge the government's control or monopoly over our healthcare system?
All quiet on the front of the those of us in the United States. One thing that comes to mind for me is that it's not just a legal challenge, it's also a challenge that can be approached through the use of technologies. So I was recently reading some interesting work on the use of blockchain in healthcare, where your health records would be your own and they would be secure on blockchain. You could bring them to whichever provider you wanted. So in some sense, I think that this isn't just a legal question. Around the edges too, I think one thing that we could put on our list of what we want to see addressed in the consultation is broader rights of private action in Canada. It is very unusual compared to the US, where there's maybe too many private actions, but for things like abuse of dominance around the edges of healthcare, as healthcare becomes not just healthcare, but also digital, could we use the tool of private actions to try to have more competition around the edges maintained when it comes to Canadian healthcare?
Interesting. Aaron, you'd mentioned other industries, or Danny, did you want to weigh in on the healthcare or no? Different systems?
I would just say that, much like Erica, a lot of the potential benefit is really on the technological side. She talked about blockchain, but we can think about so many different ways to optimize healthcare that the Canadian government hasn't really thought through, where we're seeing significant transformations across all parts of the value chain in healthcare. And this is probably the area that needs to be disrupted the most relative to any kind of tech transformation that touches any part of the lives of Canadian citizens, just given the size of health and the economy, and the fact that in many ways the healthcare system looks just as sleepy as it did 100 years ago.
Right. I'm curious, just as a follow-up, Danny, though, because it is interesting that Erica uses the idea of blockchain for your own personal records. Danny, are you seeing with your understanding of many jurisdictions around the world, are you seeing anything that's particularly interesting that we should be thinking about here, particularly since it sounds like we haven't moved in 100 years?
Yeah. So in terms of digital health, some countries are certainly further ahead. I think, first of all, many countries have moved ahead in areas that you would just wonder, how did it take this long? Psychiatry and psychology visits, for example, that they don't have to be live. Just telemedicine broadly. What countries seem to be pushing ahead at this frontier? You're seeing nibbles of it on the private side in the United States. You're seeing, some transformations in other countries around the world. I've seen some interesting work about India, for example. And it's just clear, though, that when you do have a monopoly on health, the incentive to really experiment seems to be diminished. And I think that's the world that Canada's in now. And the easiest way to bring in technological innovation is maybe change the regulatory regime around health to allow for some kinds of experimentation, and perhaps the equivalent to some kind of regulatory sandbox, but on the health and particularly on the biotech side might work.
To allow more competition. Aaron, you talked a little bit about other industries in addition to healthcare. We have a question from Alan talking a little bit about telecom. He asks, Canada has too many oligopolies that starve out the competition, and any regulatory framework to encourage competition has failed. With such strong politically entrenched players in existing markets, what can any regulatory agency do except break up the oligopolies? Telecommunications being front and center. Aaron, thoughts there?
Well, the short answer is allow foreign competition. These efforts to sort of cultivate competition within a very small market. It's no surprise. I mean, Canada is a relatively small market, and there have been attempts. It's true in telecoms, for example, to set up a fourth carrier and a fifth carrier, and these have all gone sideways. But the fundamental problem is that we have some protected incumbents, and they're shielded from foreign competition. So I think Canadians are going to have to choose if they want lower telecom prices, if they want cheaper airfares. They're going to have to choose between whether they want only majority Canadian-owned competitors, or if they're willing to welcome foreign competition, they might get their prices down a little bit. I think that's the fundamental choice. And so I agree that past attempts have failed to cultivate more competition. But with that caveat, the reason they failed is they've relied on trying to sort of artificially conjure up competition rather than simply throwing the doors open and allowing foreign competitors to join in.
And that's always been one of the points of debate in terms of whether or not, if you allow foreign investors in or foreign companies in, what does that do to your country-owned companies, and do they go by the wayside, and is that really what you want for your country 5-10 years down the road? Danny, do you want to weigh in terms of thoughts on how do you almost balance or manage? What have you seen that's worked, with the entrenched players, but allowing foreign competition in, particularly with such strong political players?
Right. So this is an issue that most of the world has, and it's not merely smaller economies. You have the same issue in the United States or China as well, and this is why we have separate regimes that focus particularly on issues involving national security. So if we lay aside those kinds of concerns and focus on industries where foreign ownership doesn't present challenges other than we believe we need to have a national champion, then the question is, well, why? So let's give two kinds of examples, and it really goes to sort of what kind of country does Canada want to be. So again, Australia's on one extreme, and the other I'd say would be Israel. So in Australia, you have traditional Australian companies in a lot of traditional sectors. You haven't had really significant change in foreign ownership for the major companies. Australia has something called tall poppy syndrome, that basically any flower that rises, they want to squash because there's a sense that you shouldn't stand out more. Then you have Israel on the other extreme that says, we're going to build up to a certain point, and then the whole point is to exit and to have somebody else buy us out. You know, we go on the NASDAQ, or we go directly to acquisition by a larger company. And this was happening in the 90s. And so back then when tech was different, tech was hardware. So Intel made strategic investments into Israel. That's what created the Pentium and the Centrium. And the whole point of Startup Nation in Israel is we want to focus on innovation and we want to sell out. And whether or not we own these companies is irrelevant. What we want to do is capture the value of dynamic innovation, and it creates a more entrepreneurial mindset in the country. It's the opposite of tall poppy syndrome. Everyone should be a tall poppy. And why? Because every Israeli mother's telling their child that they're special. And, you know, do we see more of people feeling special in Canada? I think yes. And so when we look at the future, right, the more dynamic countries are ones that are happier to sell off companies, both traditional and tech oriented. That's not a bad thing, but that really requires a certain confidence in the country and in the culture that's what you want to do. And we see these kinds of restrictions all the time in Canada. It seems to go in both ways, kind of like what Aaron was saying earlier. Well, we seem to believe in competition, but we really don't. Well, it's kind of the same way. Canadians are really proud who in Europe doesn't have their Canadian flag on their backpack when they're post-college traveling around, and yet there's, you know, media restrictions on foreign ownership, so that, you know, we have to keep on listening to Bryan Adams 30 years later. That said, the Bryan Adams tour, because I did look it up this morning, is in Canadian cities and Chicago. So that tells us something about the interchangeability of Chicago with Canada relative to, say, New York. But I'd say Canadians should feel proud, and a lot of times they do, but it's really about broader culture of how open does Canada want to be and how secure as a country does it feel in terms of something uniquely Canadian.
Yeah. Eric, you can weigh in on that, but there's also a similar type of question. Let me just pose it and then perhaps both comments. Tom is asking, how do we address the gatekeepers in competition? How would allowing foreign competition change the telecommunications and other overly protected sectors?
Sounds like similar themes to the last question. And I think part of the answer that we haven't touched on yet can be partial deregulation. And I'll give an example of that. So in the UK, the retail banking sector was highly regulated, particularly uncompetitive. And they had something called an open banking initiative, where there were new requirements for secure, private, open technical standards to allow our banking data to flow to third parties. So if you want to use an app that has all of your bank accounts in one list, you can. Before, that wasn't permitted because it was such a regulated sector. So I think telecom maybe not as simple of a solution, particularly in Canada. And I don't know that US has really figured out telecommunications competition either. But I think that there could be a role for giving footholds to upstarts through partial deregulation, like in the open banking initiative, which has really spread around the world to a lot of other countries and has led to sort of thousands of new entrants into banking adjacent services. Okay.
There's another question that Danny, you referenced a little bit earlier. Lucas is asking, do you expect in the foreseeable future that Canada will have DMA-like regulations?
So one thing that strikes me overall about Canadian policy is it tends to be much more reactive than proactive, and tries to incorporate best practices. So my sense is it's not anytime soon, and probably Canada's going to be looking very much for what are the actual effects of the DMA before deciding to move forward. So the answer is right now, we don't know what it looks like. We can all hypothesize, good, bad, neutral, unclear, but my sense is Canada's not going to move anytime quickly about this, nor frankly should it. I mean, one of the benefits of Canada sitting back and looking to see how things work out in other jurisdictions is it could take on best practices rather than worst practices.
Aaron, would you like to weigh in on this?
Yeah, I wanted to jump back to what Danny had said earlier, actually, about the culture of competition, which I think is germane. And by the way, Danny, I know you said the pursuit of the Stanley Cup is sort of the highest goal. A Canadian team hasn't won the Stanley Cup in 30 years starting next year. So I'm not sure that's the competition that Canadians want to lean into. But I think the fundamental question that we need to ask ourselves, and putting my hat on as a sort of Canadian think tank person, is competition an opportunity or is competition a threat? And I think there are a lot of Canadians that view it as a threat. And when he mentions the example of Israel, where the goal is to grow big and sell, and there's not much concern about, when we sell, is this company then owned? Is it still in Israel? In Canada, that would cause a lot of consternation because there's so much focus on protecting what we already have. Whereas in Israel, the view would simply be, well, yeah, we sold them. We'll just start another one. We'll just build another one. And the challenge, I think, that we see at the political level in Canada is that we have politicians talking out of both sides of their mouth. On the one hand, they say, we want more risk taking. We want more people starting businesses. But then anytime there's a business that loses, a business that doesn't make it, the government is there rushing in to save them. And you can't have it both ways. If you want the benefits of competition, you have to accept that it's not going to pan out for every competitor. And I think increasingly there's this attempt to have it both ways, where we want all this great competition, but we want everyone to survive, when really the whole point of competition at its most effective level is to drive out the ineffective competitors. And I don't really see a lot of policymakers who want to acknowledge that fact.
Right. And to your point, Aaron, is competition, which I think we understand the word competition and being in competitive sports is to win, which means somebody else doesn't win, or are the practices that we're trying to put in place in the reforms, is it let's have people compete, but let's also protect the competitors? And that's germane to the entire conversation today.
Well, yeah, I gotta say that you cannot have it both ways, right? If we want robust competition, we're going to have to accept some failure. That's not a bad thing, right? You don't sort of uncover those who can succeed unless you accept that there are going to be some losers in the world of business. And that I find in Canada, the discussion is always around almost this narrative that everyone can win. And you can't have that. There have to be some losers in the game. And until policymakers grapple with that, I think they're just going to be going in circles.
We have about 6 minutes left. We have one more question, and then I'll give everybody about a minute to just kind of recap their thoughts, given what we've learned from the spring. And again, your areas of expertise and where we think we should go from here. Last question is from Jim. Does your panel believe oligopolies controlled by 10 organizations or less with over 70% market share be required to become fully transparent to government auditors and file publicly available standardized financial statements? Should oligopolies be required to submit to standardized markups, profit margins, wage and bonus guidelines? A lot in that question. Makes me think about some of the wage fixing, price fixing, et cetera. Danny, do you want to weigh in on this?
In most countries, and I think the United States and China are the outliers, almost every industry is an oligopoly. And this is basically then, if we accept that as true, and we could think across any number of industries, both in the tradable and the non-tradable sectors, this is just doing business in most of the world, whether it's France or Canada or Korea or Australia, everything's an oligopoly. So this is basically a change in the governance of we should look more carefully. Well, we should be looking from the competition side. I think they do look carefully at what happens, and part of what they do is they're looking for complaints. If you think that a particular industry has a problem, go talk to the Bureau. They love hearing from people. And then the Bureau, assuming the resources are there, can investigate and see if there is potential anti-competitive conduct. Do we need some kind of broader set of issues here? I mean, I guess this is a corporate governance question, and how much publicly traded companies in Canada would reveal on with regards to their securities filings. But again, this is not a competition law type question. It intersects because it's about competition, but I think there's a distinct aspect here that is not competition specific, and it's just how do you deal with the fact that you live in a country with lots of oligopolies across industries.
Right. Erica, your thoughts? Oh, I think you were on mute.
I think Danny got it right. We tend to agree a little bit too much. We need someone who disagrees with us to join the next panel.
Aaron, what about you? Do you want to weigh in on that last question?
Yeah, all I'd say there is that, I think the focus is often on size when I think it needs to be about behavior. So this sort of assertion that size is sort of there's a suspicion that there's necessarily anti-competitive behavior, I think is unfair. Size can be an indicator of, the ability to abuse your position, but it isn't always. So I think whatever rules are in place, it should not be based solely on the size of the entity.
Okay. Let's do a final wrap here in terms of final thoughts. Erica, why don't I start with you just in terms of the conversation we've had today, the questions, and of course, the fact that we've had the reform, but open to conversation. Parting words, parting thoughts?
Yeah, we covered an exceptionally wide array of themes, but I think that really there's two messages here, if I could summarize. So I think that repeatedly we've come down to sort of the need for specificity in problem framing when it comes to digital economic regulation. So what is it we are trying to achieve with these laws? What is the harm we are trying to address? What is the company they are going to apply to? I'm as guilty as everyone else of using the term big tech. Is it a software company? Is it a hardware company? Is it a consumer products company? They're all very distinct. And so specificity can really help in shaping appropriate digital policy. And these debates can get very general. And I think the sort of second message we can take away from this is there has to be some sort of elegance and flexibility to make regulation and law that can stand the test of time in this space. Technology is always going to outpace law. So how do we design not in a reactive way just because there are concerns about the digital economy, but in a way that is durable and doesn't have too many unintended consequences, which was a theme that came up pretty frequently in our discussion today. So thank you so much, Catherine and Aaron.
Absolutely. Danny, your final thoughts and message to our viewers?
Very quickly ask, what is the behavior we want to regulate? If there are multiple goals, how do we mediate across these goals in a way that distorts the economy the least amount, if you're going to do so? And ask yourself the fundamental question, is this a competition law issue, or is this a broader policy discussion that touches upon other areas with other goals, and which is the best institutional choice? Because as much as I'd like to say that everything is about competition law, I just don't think that's right.
Thank you for being so honest. Aaron, last word to you. We've got about 30 seconds.
Yeah, sure. I first want to join in with Danny in saying I think part of the thing I'd like to see is having the Competition Bureau get more resources. So if you're watching from the Competition Bureau, you're welcome. But I think I would say one very important thing is that we need to guard against mission creep. I think we've seen what can happen to institutions right now. The Bank of Canada is the example I'm talking about. If they try and do too many things, the Competition Bureau should be focused on consumer welfare and ensuring that Canadians are well served by competition. If they divert from that goal, I think they may run into an issue with public trust. They may end up not doing anything at all well. And I think in this day and age of skepticism, that could be a very big problem.
Okay, we will conclude the webinar today. Thank you everybody for joining, for watching, for listening, and of course to our panelists. Thank you so much.